Good morning. My name is Faris Natour, and I'm the director of BSR's Human Rights Practice. And it's my great pleasure to introduce our next panel here this morning. We'll actually stick with the theme of technology, but we'll switch from nerds to lawyers. I know. I can feel the excitement in the room. Please stay. Now, let's do a quick show of hands. Who has worked inside their company on human rights issues before? Quite a few people. So you probably are familiar with this feeling. And when you work on human rights inside a company, hearing the words general counsel usually means your work coming to a grinding halt, right? If you experience this, you're never going to get this policy approved. The lawyers are getting involved. Well, we'll soon hear that it doesn't have to be this way. With Brad Smith from Microsoft and Mark Chandler from Cisco, we have two general counsels here today who've been really advocating for human rights within their companies and beyond, and they will share some of the great work they're doing with us today. And there's no one better to moderate this discussion than Eileen Donahoe. She's a true human rights advocate in her own right. Eileen is the Director of Global Affairs at Human Rights Watch, where she focuses on internet freedom and privacy. And she has also served as the US Ambassador to the UN Human Rights Council in Geneva. So with that, please join me in welcoming Eileen, Brad, and Mark. Thank you.
Thank you, Faris. Let me start by saying how noteworthy it is that we have with us on the stage today two of the most highly respected private sector general counsels in the world, engaging in a conversation about the role of human rights and the potential for collaborative action. Brad Smith is general counsel and executive vice president of legal and corporate affairs at Microsoft. He leads approximately 1,100 legal, business, and corporate affairs professionals spanning 55 countries, and is responsible for the company's legal work, its intellectual property portfolio, patent licensing business, and the company's government affairs, public policy, corporate citizenship, and philanthropic work. He's helped the company achieve consistent ranking in the top 2% of the S&P 500 for corporate governance scores, and in 2013 he was named by the National Law Journal as one of the 100 most influential lawyers in the United States, and in 2014 the New York Times called Brad a de facto ambassador for the technology industry at large. Mark Chandler is Senior Vice President, General Counsel, and Secretary and Chief Compliance Officer at Cisco. He manages a team of 450 professionals, including legal, employee relations, ethics, investigations, and brand protection teams. He previously was managing attorney for the Europe, Middle East, and Africa region based in Paris. And in 2010, the National Law Journal named Mark one of the 40 most influential lawyers of the decade. And in 2013, American lawyers numbered him among the top 50 big law innovators in the last 50 years. So welcome to you both. Your presence speaks volumes about your own individual leadership and about the leadership of Microsoft and Cisco in this realm. But it also speaks to the importance and centrality of human rights to global society today. Let me quickly mention to the audience, we're going to take questions at the end. We're short on time, so start formulating now. This panel is basically focused on the technology sector's collective efforts to protect human rights in the digital realm. And to frame this conversation, I want to start with a simple acknowledgement and state the obvious. This is an exceedingly complex area, and we are in a period of profound societal change and disruption, almost a tectonic shift brought on by rapid expansion of ICT and exponential adoption of digital technology. None of our social, political, or legal institutions have caught up with the implications of this shift, and our understanding of how to protect human rights is being deeply challenged. Specifically, the well-established human rights framework envisions the primary relationship between governments and their citizens, where governments have a duty not to violate their own citizens' rights, as well as the obligation to protect human rights abuses from others. The UN Guiding Principles for Business and Human Rights reaffirms this principle, but elaborates the responsibility of non-state actor businesses to respect human rights. Several significant global shifts have challenged this basic model. Let me mention three really briefly. Number one, the internet itself, which in many ways has been a boon to the exercise of human rights, but also contributed to the distribution of power away from governments to non-state actors, and challenged the so-called Westphalian system, which rests on the concept of a sovereign nation state, geographical territorial boundaries, and the principle of non-intervention. A significant portion of this power has been distributed away from governments to the private sector, especially tech companies. And we've now seen states frequently relying and even requiring private sector businesses to facilitate law enforcement and foreign intelligence surveillance. Second phenomenon is digitization itself. While advancement in digital technology has many positive effects, it also has meant that governments have advanced ability to monitor citizens' movements, censor speech, block, filter access to information, and track communications. This obviously puts privacy under assault, but it also has important negative implications for the exercise of all fundamental freedoms. And the core idea is really simple. When everything you say or do can be tracked, intercepted, monitored, or surveilled by your government, it has a chilling effect on what you feel free to say, where you feel free to go, and with whom you choose to meet. And last but not least, I will mention as a challenge to the human rights framework has been the follow-on response of many governments around the world to the Snowden revelations, where with lots of mixed motivations, governments have proposed regulations on businesses related to data retention, data localization, sometimes with good intentions, sometimes not, but which also may have the effect of fragmenting the open, interoperable internet as a global platform. And from a human rights point of view, the loss or fragmentation of the internet would be a tragic result because the internet itself has facilitated so much human rights work. So bottom line, digitization has positively and negatively affected human rights in complex ways. So let me turn to Brad and Mark and ask the most basic general question, independent of Snowden revelations. Maybe starting with Mark, what is the basic framework you use at Cisco for understanding human rights, and what role, if any, do the UN guiding principles play in that understanding?
Thanks, Eileen. I think your introduction and discussion was wonderful. We've known each other about, 15 years through your work at Stanford. And I think everybody here should know and recognize that President Obama showed a huge amount of foresight and vision and commitment in asking you to lead the effort in Geneva. Not just all of us here, but I think around the world, people are very, very grateful for your service. Thank you for all you're doing. Internally, that framework and process depended on first overcoming two hurdles that were actually the most difficult ones because they were conceptual. The first was moving out of what I can only call a defensive crouch. From when the issue first arose, a sense of many people inside our company certainly, and maybe others as well, that there was a picking on big companies who were supplying lawful products that the companies believed were actually helping the cause of broadening communication, and using them as a tool for issues that weren't really within the core wheelhouse of the company. I'm saying it was important to step out of that and move beyond that thinking. And second, and equally difficult, was to then come up with a proactive framework that would allow us to then set a set of principles that we thought could allow us to be effective in the world in driving a cause that was very important to the credible dissemination of digital products around the world. So having thought that through, and that was really an intellectual process and a buy-in process, we then came up with a framework that's very similar to what's used to comply with other expectations that we set for ourselves. First, to have a very clear policy informed by the UN Global Declaration, by the guiding principles, by the ILO core labor standards, and state that policy very clearly and publicize it so that people knew about it. Second was to set up a training process so people knew what the expectations were within the company. In fact, we've rolled out training for all our employees, mandatory for a significant group of employees who face these issues daily, that let them know what those principles are, how the company is behind them, and what we expect people to do to comply with them. Third, a due diligence process to be able to identify who our business partners are, how they're using our products, and what we can do about that, and to learn and investigate issues that arise where people raise questions about, are we doing the right thing in that place? How does this relate back to the principles that we say we espouse? And finally, how do we investigate and address issues and remediate them when they arise? And using those 4 steps, which we use broadly across the company in a number of areas, applying it to human rights and agreeing that we have an obligation to do that has really been the process that we followed and the journey we've been on.
Great. And Brad, you too, also perhaps because Microsoft is a member of GNI, perhaps you could touch on that.
Sure. I mean, I think, first of all, it's great to be here with both of you, and Mark and I have had the chance to work on issues like these and others for quite a while. Yeah, I think when we consider these human rights questions, we try to keep in mind 3 things. First, this is complicated, as you said. It's nuanced, it's difficult. I mean, the people in this room are doing work that's not only important, but frequently quite challenging intellectually, as well as in many other respects, as I think Mark captured. Second, I think that's why it's all the more important to try to take an approach to each issue that is principled. Principled so it's clear not only what we're doing, but why, and why in a form that we can explain externally. It certainly starts with things like the UN guiding principles. The principles in the Global Network Initiative, GNI, I think are helpful to us. We were one of the first American companies to sign the Global Compact a number of years ago. And then we often find when we get to very specific issues, we really need to develop some specific principles. We've often done that to deal with each challenge. And the truth of the matter is our best work usually comes when we get really good advice from people outside the company. I guess the buzzword is multi-stakeholder engagement. I like to think about it more as getting free advice from people who know more than we do. It's really how you make better decisions. And then third, you have to do what I think Mark described very well. Once you have a set of principles, you have to build the infrastructure to implement them. They need to be transformed into policies, there need to be business processes, there need to be compliance and grievance regimes, there need to be training. These things don't happen by themselves, they're not self-executing. Frankly, it takes good people who are really dedicated to this. And then hopefully, you have a course to steer and you can stick to it. And without that clear course, I just think it's just impossible to manage these kinds of challenges.
Mm-hmm. So I want to turn more specifically to the focus of this panel and questions about privacy, trust, and security. And I want to ask both of you to describe the changed environment post-Snowden in terms of trust in U.S. tech businesses. I want to mention a letter last summer to President Obama by Cisco CEO John Chambers, who warned the administration about significant erosion of trust in the U.S. tech sector due to NSA surveillance. And Microsoft CEO Satya Nadella joined CEOs of Google, Facebook, Twitter, AOL, Dropbox, LinkedIn, and Yahoo, also calling for urgent reform to stop the global erosion of trust in U.S. companies. So just how do you see the erosion of trust, credibility, and consumer confidence in the tech sector post-Snowden? And do you think it's possible to remedy that damage? And if so, how?
Well, I think, first of all, we always have to start with the premise that trust is fundamental to our business. You wouldn't put your money in a bank if you didn't trust that it was going to be there when you went to retrieve it. The same thing is true today for everybody's most important personal information. So, it's just a prerequisite for success. Trust has been under stress. We try to measure it every year in various ways. We do some polling in national capitals around the world. We ask consumers, we ask government officials, we ask academics about their trust in technology. We ask about trust in different companies. And what we've seen is not a uniform impact around the world, but we have seen a double-digit decline, 10 to 15 points. In places like Berlin and Brussels and Brasilia and a number of other capitals. So that tells us something that's quantifiable. I see it anecdotally when I meet with people. One of the more compelling statements that I've heard over the last year was when I was in Berlin in May, and the CIO of a German state said to me, look, there's just no way we could even consider putting our data in a data center run by an American company unless these issues are turned around. Ultimately, I think you are asking the right question. Can we turn it around? We have no choice. We must. It's a business imperative. I believe we can, but there is a lot of work ahead of us to achieve that.
Let me just ask, I know Microsoft has been involved in a case about the extraterritorial reach of US jurisdiction into data stored abroad. And I'm wondering, to what extent is US government failure to extend privacy protections to citizens outside US territory and their understanding of that extraterritorial reach the core of this problem? Maybe you can tell us a little about this case.
Sure. I do believe it is one of the things at the core of this problem. Absolutely. Basically, around the world, individuals, sometimes consumers, oftentimes businesses, in many countries, governments and public sector entities want to know whether their data is going to be accessed by the US government without their consent and even without their knowledge. And if there's one thing that's basically almost universal, is that in most countries, most people have more confidence and trust in their own government than in a foreign government. So it's a real issue on people's minds in a very significant way. Unfortunately, in my opinion, the US government has taken the position that it can serve a search warrant on a data center that is operated outside the United States by an American company, and it can reach into that data center and in effect grab the email, the text messages, the photos, the other personal content that sits inside. And to me, this is a classic breach of traditional sovereignty in the Westphalian concept. The classic attribute of sovereignty is the ability to exercise police power. You can exercise police power within your own borders. You can't exercise police power within another country's borders unless you're prepared to invade it. But now, using this doctrine, the US government is saying that it can. We have challenged that. We challenged a warrant here in New York. We went to the Southern District of New York. We're now up on appeal to the Second Circuit. Cisco is very helpful. It's an important amicus participant in this case. And we're basically saying that under the Electronic Communications Privacy Act, warrants do what they have always done. They reach to the shore of the United States of America. They do not reach around the world. If the US government wants to reach around the world, it needs to work with governments elsewhere.
Let me just mention from a human rights point of view, the US jurisdictional reach abroad on the one hand into other countries is inconsistent with the argument they make about the lack of extraterritorial application of human rights obligations. So on the one hand, they want to reach in. On the other hand, they don't want their human rights obligations to apply. So there's an inconsistency there. Mark, let me turn to you and ask the same thing about trust. How can we remedy it? And I want to ask a little bit about how worried are you about trust in the open, interoperable internet itself? And how worried are you about fragmentation or so-called balkanization?
First, I just would elaborate on what Brad said, and we're very happy to be in a position to provide whatever support we can in that litigation that you've undertaken with the government. It's a fundamental human right that we should be free from unwarranted searches of our persons and property by governments. We fought a revolution over that in this country. And by the way, there's no more effective exegesis of the history of that and the relevance in the digital age than the speech that you gave, Brad, at Brookings in June. And I checked this morning, if you Google Brad Smith Microsoft Brookings speech, you can watch the speech as well.
And if you Bing it, you can too. I just want to point that out.
Thanks. Sorry about that. If you search on it, you can find it. And I was going to say it also is a wonderful illustration, which a lot of people need, on the very effective use of PowerPoint to illustrate a speech.
There you go. Thank you, Mark.
So you got a plug. I think you go back on that question to the principles that I alluded to but didn't enumerate in describing our setting of a policy on human rights. For us, the most critical principles were in our own business that we wouldn't modify our products in any way that supported repression. We wouldn't sell products into situations that we felt where it was clear they were going to be used in a way that would violate fundamental human rights standards. And third, that we would always support an open, unbalkanized global internet supported by multiple private sector stakeholders. By private sector, I include NGO community as well. I mean non-governmental stakeholders, as really critical to maintaining an open internet. The Snowden affair has created many opportunities to undermine some of those principles. And first, I think the revelations are being leveraged by those who try to establish an equivalency between the types of principles that Brad's company operates under, that we try to as well, and perhaps others who don't, and by establishing an equivalency thereby undermine the effectiveness of operations of companies that really do have human rights principles. I think it's important to remember that there's a global game that gets played out of these things at the same time that very significant issues are raised. Second, it's raised questions about the degree to which companies, and this is part of that first point I just made, companies are somehow enabling governments to do these things. And I think when Brad refers to receiving a search warrant and fighting it, that's an example of pushing back against that. The type of issues that we've experienced in the infrastructure, as an infrastructure supplier, are finding out that the government was intercepting products after they left our control and compromising the integrity of those products. And one of the things we asked was that the government not do that. That the government, instead of, like all our other customers, and I think you're dependent on this as well, coming to us when a vulnerability is found, some way that the product can be undermined, and we expect our customers to come to us and tell us and say, you need to fix this. Look, someone can exploit this vulnerability. We learned that the government was actually stockpiling some of those to be used operationally. We thought there should be very strict limits on that as well. If you take those kinds of steps, you can restore confidence. At this point, I think the view of the government has been, well, they operate in a difficult world. The tension between security and freedom is a very difficult one. There's no question that there are very clear and present dangers, that there is perhaps no greater threat to free governments than having a series of terrorist events with loss of many innocent lives, which then creates a reaction where citizens want, in some hierarchy of need sense, want physical security more than anything else. You can undermine freedom that way. So we understand that tension. But at the same time, the government has not seemed to want to be proactive in setting limits on those activities that would allow for removal of that kind of cloud. And I think that leads to the final point that you were asking about. There are a variety of efforts by states that have not been champions of human rights in the past to change the nature of internet governance to one that would be subject to more state control, to more local standards, not to a globalized, standardized internet. And those threats to human rights are very, very real. And to me, that's the most significant impact of the Snowden affair, is enabling and empowering those who would undermine a global standards-based internet. And I think our government needs to do a lot more to make sure, as internet governance evolves, that they don't unwittingly create an environment where a free global internet is undermined.
Yep. You mentioned the incident of Cisco products being compromised en route to customers. I want to turn to another subject of digital security for users and the movement toward greater use of encryption technology. I want to ask each of you, how do you react to US and UK comments such as those as FBI Director Comey and those just a couple days ago by GCHQ Director Hannigan, when they criticize the motivations and intentions of US companies as they strengthen encryption and other digital technology tools?
My reaction is simple. Look, if we're going to better protect people's privacy and if we're going to do a better job of sustaining trust, there's only two ways we can do it: stronger technology and better laws. Our industry has been forced to adopt better technology, stronger technology, more encryption, in the cloud and on devices. If those in government are concerned about the technology arms race that has been unleashed, and I do think there is some cause for some reservations, then the alternative is equally clear. It's called better laws. And so if they want to get back to a place where everyone can feel better, we all need to come to the table, we all need to sit down, and we all need to figure out how to write the right laws that are going to have the kind of balance that people are going to respect. But the one thing that will not work is for people in government to object to technology companies adopting stronger technology when they themselves are not prepared to consider better laws.
Okay. Do you want to comment on the security question?
I think Brad has said it exactly right when I say the government has not been responsive to what the implications are of the Snowden revelations in terms of, I was referring to need for better laws and to put some self-limits on what's being done. And I view the response of companies to then provide that security directly for their customers as the only logical thing that you can do as a supplier that depends on the trust of your customers than to take those steps. And I think Brad said it exactly right. So
let me just ask the obvious question. What is the prospect of reform in the US in terms of laws related to surveillance, and what kind of collective role is there for the tech sector?
Well, we're working together, and I think that's extremely important. Even those of us who are competitors, sometimes we're even on opposite sides of regulatory issues. Nonetheless, most days are working together arm in arm on these issues. I think that's extremely important. I think the good news is there's three opportunities in effect for reform. There's reform through the courts, reform through Congress, and reform by the executive branch. And we're seeking all three. We're litigating to ask the courts to intervene. We're going to Congress. There is legislation. Obviously, this year it made it out of the House. One could still hope that the lame duck session will complete passage of the USA Freedom Act. Senator Leahy is certainly staying focused on this. Bob Goodlatte in the House has helped as chair of the Judiciary Committee. So I have hope. And I think there is an additional opportunity for decision-making by the executive branch. I believe that before the end of 2014, we need President Obama to put together an interagency task force so that the executive branch can take the next steps on its reform efforts. And I believe we're fortunate to have a president who is a former constitutional law professor. That's only happened a couple of times in the nation's history. I think that he appreciates the complexity of these issues. But I don't believe that the executive branch will go where it needs to go unless there is more White House leadership and an interagency task force to get the government on the executive side on the same page. So I have hope, even a little bit of optimism.
Great.
I think there, and maybe I'll be the other side of the scale on Brad's optimism and talk for a second about what some of the challenges are to get that done. One of the first is to have people who are concerned about these issues to be raising those issues. I've been in several discussions where it was clear that the metadata collection, which isn't one of the subjects that we've been talking about here, has sucked up a huge amount of the oxygen in the public discussion of these issues. So issues affecting infrastructure, affecting intelligence gathering, that's directly from companies such as the issue you're confronting in the search warrant under ECPA issue, have not been front and center. And I think the administration has perhaps not felt the public input on these issues that's going to be essential to get focus on getting something done. So everybody ought to be speaking up about these issues as well. I think second, it's important to remember that there's actually a bipartisan support for this, that this is not a partisan issue, that concerns about overreach by government is shared in both parties, and it's important to work closely, and Brad has alluded to that as well, but to work closely across the political spectrum on these issues and make sure it's understood why they're important. And I think third, it's important to channel and remember what the people who are protecting national security are thinking and feeling as they go through this, and to try to come up with solutions that allow for legitimate efforts to protect national security and protect all of us, really. In some conversations, people have said to me who are involved in that work have said, well, you want these changes in practices. How many innocent people should die? Just tell me how many lives should be lost to make these changes, and we can maybe ratchet our procedures so that we try to limit it to that many dead people. And at first, I felt manipulated by that input, but I've come to realize that the people who say that and feel that way lie awake half the night, every night, thinking about what threats are out there and what they can be doing about it, and they take that mission of protecting people extremely seriously. And so in coming up with solutions such as making sure that we know what vulnerabilities are in our products so we can protect all our users, in making sure that there isn't extraterritorial reach of search warrant capabilities, of making sure that products aren't being compromised in a way that the vast majority of customers never should have to worry about happening to their products and their data, that we think those through in a way that come up with practical solutions. I think USA Freedom Act is a first step down that, and there are a variety of others that are needed. I think if we all get very active, we reach across the political spectrum, and we remember what the people who are putting some of these steps in place are thinking and what their mission is, we can come up with solutions that will go a long way towards solving this problem. And
if I could, I just think Mark raises an extremely important point, and just to build on it in two quick ways. One is, I do think it's important for people to have a sense that, of course, public safety is of vital importance, as is the protection of privacy. I do think right now inside the Beltway, there are a number of people, especially in the intelligence community and the national security community, who would say, gee, because the world is more dangerous and feels more dangerous in November than it did in January, because we have in effect, a war that we're fighting in Syria and Iraq again, that somehow these issues are now off the front burner. And I just think that's a mistake, and it's important for people to use their voice because of that. Second, when it comes to the public safety issues, or when it comes to the question that was put to you, Mark, I just think it's so important to keep in mind what others call the fallacy of the last move. A lot of decisions make sense if you're the last one to make the move. But because the sun always rises tomorrow, no one ever gets to make the last move. So there can be folks at the FBI who say, no, I don't want to give up the ability to serve a warrant outside the United States. The world will be less safe if that happens. And I say, well, yes, but if people outside the United States don't have confidence that their own laws and legal protections and constitutions will prevail, they're not going to give you the opportunity to make the last move. They will simply decide that all data in their country is stored in data centers run by their companies. And then your ability to do anything goes away. So it's oftentimes not as simple as it first appears.
Yeah, it's a dynamic world. It's not static. Today, this set of policies may seem to get more access to data. Tomorrow, it will be ineffective for the reason Brad says. But there are things that we can do as well, and along the lines of the encryption, where we can architect data center solutions so that we can assure customers that their data is outside the reach of U.S. search warrants.
So
we are doing that.
Yeah, that's another very good point.
I think we're going to have to turn to the audience. I have to say, on this subject of the tension between freedom and security, it's very important to not frame those issues as binary or zero-sum.
Right.
In the U.S., in our constitutional system, and in the human rights framework, both freedom and security are essential. They're mutually reinforcing. And I think we need to think about it more as, sort of a rather than zero-sum multivariable calculus. We've got to solve for more than one variable. If we give up on freedom, we will have undermined our security, and that's the basis of our system. So I guess let me mention one other thing for collaborative action on the tech community. There's an initiative at the UN that's being undertaken right now to potentially establish a mandate holder, an international expert, to help clarify and give conceptual clarity on the policy framework with respect to privacy and security. And it's being led by Brazil and Germany. Civil society is behind it, and I encourage you to look into that as something the tech community could get behind, because I think having a dedicated expert would be much appreciated and very useful. So maybe let's turn to the audience and see if there are questions. I see a hand right here, and perhaps quickly identify yourself.
I have two, so you can have one of them.
Hi, David Wofford with a small business called Meridian Group International. We do health work with factories around the world. Just a quick question. People in Washington, D.C. on the security side also say another argument, which is, look, people give incredible amounts of private information to all these tech companies, which suck them up and use it and sell things online as part of the business model. So, I hear them saying, why, you don't want the government to make us safe, but you're perfectly willing to allow any company to know almost everything about you through the photos and other things. And so you get this argument like privacy is sort of a false issue because we're giving up incredibly private information. I wonder if you get that too, and what your response to that is.
I certainly get it a lot, and my response is twofold. First, I think it's a very reasonable and legitimate point of view for people to raise. I think one needs to acknowledge that the questions that people have about fundamental protection of privacy need to be addressed in a thoughtful and balanced way, not only when it comes to how governments access people's information, but how companies access and use people's information. And there is ample room for more discussion and even, I think, better protection of people's privacy. Second, the other aspect that I often get is the other sort of implicit or explicit part of your question. They're sort of saying, well, gee, given that people give up all this information, doesn't it really mean they don't care about privacy at all? So what are you whining about? My response is, the fact that people share more information than they used to does not, in my opinion, necessarily mean that they care less about privacy. I just think it means that the definition of privacy has perhaps changed. In my generation growing up, it was often more thought about as keeping something secret. I think for a younger generation, it's less about keeping something secret, but they do want to control who they share information with and what those people do with that information. Any of us who've had kids have often experienced the fact that kids are very comfortable sharing information with their friends, but they may not want to share certain information with their parents. And by the way, I think that was probably true a generation or 2 or 3 or 18 ago as well. So, I think across the board, this is an important topic.
Yeah, I think there's another aspect to this as well. I think there's some if not irony, maybe it's appropriate rather than ironic that we have this debate in the United States where we do have a constitutional system and we have open debate. You know, we're confronted with, we had a situation where we had another government that wanted to buy our products and video surveillance management software and wanted to combine it with biometrics in order to be able to track individuals' movements around cities by being able to designate individuals that they wanted to follow. I think the privacy issues that we're confronting in this country with, and the type of debate we're having post-Snowden ought to also be put in the global context and remember the very real threat to human liberties and fundamental human rights that are posed by governments getting too much ability to grab whatever information they want without any public process, disclosure, or protections for individuals. And there are many states around the world that feel both empowered and that they're acting appropriately in doing so. And that's where the human rights and digital freedoms issues first arose 7, 8, 10 years ago. And I think the focus shouldn't come off of that as well.
Great. I think, unfortunately, our time is up, and I want to thank you both very much for engaging here.
Thank you.